So welcome back. We continue on our journey studying the Bill of Rights. Just as a reminder, the test will be Friday, April 22nd. That is for all sections, 1859, 1862, 1860. You will all have the test on Friday, April 22nd. Okay? More details to come. I'll, I'll give you time to take it, of course, but we'll discuss that in coming classes. All right, so Amendment 4 will be the end of what we'll have on Test 3. So after this topic is done being discussed, we're going right into the final, okay? So what will be on the test are as follows. Political parties, the road to the White House, the war powers, the presidency, the Congress, the Supreme Court, and Amendments 2, 3, 4. Okay, again, it's all right. Well, I haven't uploaded what I'm recording now yet, but political parties, the road to the White House, the presidency, the war powers. So this is the presidency, the war powers. Don't worry about this. Congress, the Supreme Court, and I'm recording Amendment 4 right now, and I'll upload Amendments 2 and 3 and the rest of the Supreme Court. So that's the test. Don't freak out about it. I'll give you the time you need. I'll present you with a game plan in the coming days. So, Amendment 4. So, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So what does this all mean? What are the protections offered by Amendment 4? What are the procedural protections we have? We have persons, houses, papers, and effects that are described particularly. So persons, the clothes you're wearing, the wallet you have, your blood or bodily fluid. Yes, all those things are protected under the auspices of the Fourth Amendment, unless your blood or your bodily fluid, whatever that might mean, leaves your body, then it is not protected under the Fourth Amendment. So if you give blood at the doctor's, that blood is not your property. If you give blood to, anybody, if it escapes your body, it's not yours. We'll just leave it there. Papers, your diary or journal, a book in your house, your email, text messages, a book. Whatever I might be keeping in here. I'm not keeping anything in here, but this is protected. Somebody would have to come in a warrant saying, I want to search your copy of Legacy of Ashes. Somebody would have to come in. Yes, I am a nerd. I do write in a journal from time to time. You know this about me by now. Someone would have to come in, particularly with a warrant, to look at the journal that I keep. Email, text messages, I hope you all know that those are in no way, shape, or form protected under the Fourth Amendment at all. Your ICC email is subject to search by ICC if they suspect you of being up to something. Your phones, this least secure thing on earth. Anybody with the know-how can get into my cell phone and read my text messages. Your emails, text messages, so not protected Don't be saying anything in an email or a text message that you don't want your next door neighbor to know, because they're just not private. Effects. Your backpack. This whole thing works better in a classroom. Your iPod. Because I should probably change that. I don't think many of you have iPods anymore. A stamp collection. I leave this one in on purpose. I've had 3 students in 2 years have stamp collections. If you have a stamp collection, shoot me an email. I'd like to see pictures. Yes, to all 3. So houses, like just getting back to your backpack. Now there are some instances where that might not be protected. So like, since if we were all back at ICC, you'd have a greater amount of protection from by the Fourth Amendment than you would at your high schools. Still, say if one of you came in, obviously rip-roaring drunk, fell over 3 times trying to get to your seat, and then threw up on the floor, I would have reasonable cause to take a look in your backpack for the bottle of vodka. So, I mean, it's not absolute as far as you're concerned in a college, but you do have much greater protection under the Fourth Amendment in a college setting whenever we get back there, and I hope it's the fall, than you would in your high schools. So houses, pretty self-explanatory. Even an apartment, my landlord's got to call 24 hours in advance before he enters this place. Even though this is he physically built what you see in the background. I mean, it is his property in every sense of the word, but he rents it out, and the way that works legally is that my wife, who's sitting in the back behind me there, and I have very much an expectation of privacy, and we have control of these premises for as long as the contract between the 2 of us and him last. So that's self-explanatory. So a mobile home may not be protected, depending on whether it's being used as a home or a car. So if you've got it parked in a trailer park and are living in an RV, yeah, then that's a home. If you're just driving an RV around because you want your kids to have a place to take a nap, on the 300-mile drive from Illinois to Colorado or Utah, then okay. I know that doesn't work out to 300 miles, but you take my point. So it protects all those who live under the protection of the Constitution, this Fourth Amendment, even undocumented immigrants, because the Supreme Court has ruled that the Constitution follows the flag. Wherever and whenever, wherever the flag's flown, there lives the Constitution. Now, a student here inevitably always asks at this point about Guantanamo Bay. And if the Constitution follows the flag, why do we have prisoners down in Guantanamo Bay that are going to be there until the day they die? The answer to that, very generally, without turning this into a law of armed conflict class, here's the system we have, here's the system we should have, and the Constitution follows the flag unless it doesn't. That's about the best way I can answer that. So while it is a territory we've rented out from the Cubans, and our flag does fly over Guantanamo, the constitutional rights, unless they follow the flag, unless they don't. That's about all I can say on the subject. What does it protect from? So against unreasonable searches and seizures. So I can't come up to you if we were still in a classroom and say, David Hernandez, open up your backpack right now. I want to take a look at what you have. David is a very nice guy. David would very politely say, no, I don't think I will. No, thank you, sir. And move on. But that would be an unreasonable search and seizure on my part. So the courts have to look to balance individual liberty with the need to keep an ordered society. So would society would the society be more ordered or more in disarray if we let, like, Guantanamo Bay detainees have rights, have constitutional rights? That's that isn't a difficult question, but there are a lot of factors there. But I'm going to get off Guantanamo now. So as you sit in this class, you're not sitting in this class. As you're sitting in this virtual classroom, whether that be your couch in the living room, your bed, at your desk, wherever, you have personal effects on you. You certainly do. What right do you have to keep these things private? Well, since you're not in a public place, hopefully, I hope none of you are in public places, you have an absolute right to keep these things private. If you were with me in room 225, it'd be less so. Privacy, your right to privacy changes depending upon where you are. So, does the Constitution protect against unreasonable searches and seizures while you're in school without a warrant based on probable cause? The answer is usually yes. Again, that goes back to, you come in obviously drunk and you stumble 3 times trying to get to your seat and then you throw up. I could look in the bag without having a warrant. That's what that is. So what are the rules? And this is leading up to a Supreme Court case. So what are the rules governing official school searches of students and their belongings for drugs, weapons, and other harmful things? So some believe school authorities, and this is more high school than you guys, should be forced to go to court and prove probable cause and get a search warrant from a judge. And this is one school of thought. Others think that school should act in loco parentis, so in place of the parent. So schools should simply have the right to search students and their property however and whenever they want. So the Supreme Court hasn't come down definitively on either side of this issue. They have agreed that students have rights, but they are diminished whilst they are in school. So we come to New Jersey versus TLO, and this is why we're talking about schools, because this takes place in a high school in the 80s. So the question posed in New Jersey versus TLO, and hold on. Test, definitely. I ask about this. All right. So do public school officials need probable cause or a warrant to search a student's purse when they believe she was smoking cigarettes in school? It's she because it was a she in this case. So a 14-year-old student, she was a minor when this happened, so they didn't use her full name. They just call her TLO, her initials. She was suspected of smoking cigarettes in the bathroom with another student. She was smoking cigarettes in the bathroom with another student. She wasn't suspected of it. Both girls were brought to the principal's office. TLO denied smoking. The other girl confessed. So the funny thing about this, I mean, if you want to call it funny, it was the 1980s. All TLO and her friend would have needed to do was walk out the door and stand in the school's designated smoking spot. I remember those when I was in middle school. They had them for the faculty, not for us, but they were still, the teachers went outside and had a cigarette when they weren't teaching. So all she would have had to do was leave the building. It was against school rules to smoke inside. She would have just had to walk out the door. So the principal said, I don't really believe you. I can smell the cigarette smoke on you very forcefully. I'm going to search your purse. So he did so. He found a pack of cigarettes. And after finding these cigarettes, he continued his search and he found marijuana and marijuana-related paraphernalia. So TLO wasn't too happy about this. She was duly punished, and during her juvenile prosecution, she challenged the principal's search as a violation of her Fourth Amendment rights. Were TLO's Fourth Amendment rights violated? Well, wait and see. So the court held that the Fourth Amendment applies to high school students in public schools, and that students retain a limited reasonable expectation of privacy. And the court upheld the constitutionality of the search. So no, her rights weren't violated. Reasoning that they said the principal had reasonable suspicion to search the purse for a violation of school rules. So the initial search was reasonable because the principal suspected that TLO violated the rules of not smoking in the school building. And the second continued search of the purse was reasonable because the cigarettes and other suspicious items had been found. So because TLO smelled the smoke, okay, we can go in the purse. Because we found things in the purse, we can keep searching. No Fourth Amendment violation. So the legal issues at play, does the Fourth Amendment even apply to high school students? Man, I need to edit better. The state of New Jersey argued that because of the extensive, and it was very extensive at the time, regulations that students have to follow in schools, they did not retain any real reasonable expectation of privacy. And the Supreme Court said, well, hold on. They have a little bit. They have some expectation of privacy in the things that they bring to school. They shouldn't be subjected to just searches summarily without any real reason. And I skipped ahead more than I meant to. Hold on. Should the probable cause or warrant requirement be applied to a school setting? So as the court held that to a lesser standard, I mean, that really was made more sense in the context of a school. So the court adopted the reasonable suspicion standard, holding that if the search is reasonable considering all of the circumstances, the court offered a two-part test. So one, whether the search is justified at its inception. Two, whether the search was reasonably related in scope to the justification. And we'll come back for part two in a moment.